Well, I'll get started oh, there we go. All right. Sorry about that, everyone. So as I was saying, the first thing we're going to talk about is delaying a written offer letter until long after the start date. This is important as you're bringing on new employees to formalize the process, not to have somebody work for you for months or even years at a time before bringing the employee or providing the employee with a written offer letter, laying out the terms of employment. If that's an employment agreement, which it's not often the case that it is, but the offer letter, the agreement needs to be provided to the employee and signed at the onset and as you're onboarding. Another mistake that we often see is classifying everybody as a consultant or contractor rather than an employee. There's very rigid factors that you need to consider as you're bringing on individuals to determine whether or not they're an independent contractor, an employee, and we're going to get into that later on in the presentation. But again, we see that mistake where companies will classify everybody as an independent contractor or consultant. The next thing is along those lines, and that's thinking that the salaried status of an employee will excuse overtime pay. Again, that's not always the case, and that's a common mistake. The next point we're going to discuss today is failing to ensure that incoming employees are not breaching confidentiality and non-compete obligations to a former employer. Again, we'll discuss this later on, but the thing that we want to consider here is avoiding unnecessary litigation. And if you're bringing on employees that are bound by restrictive covenants from their prior employer, you need to make sure that your incoming employees, as you're onboarding them, make you aware of those. And that's something that they would do through that offer letter and making sure that they sign something. And again, we'll touch on that in detail later. The next will be failing to ensure that workers execute sufficient confidentiality and IP assignment and restrictive covenants. That would be a part of a employment agreement, and that is to protect yourself in the case of turnover and employee departures. And then the last thing we're going to talk about is high risk employee terminations and making sure that you talk to a lawyer before you discharge or terminate the employment of somebody that's working for you. Again, hopefully avoiding litigation and unnecessary expenses.
Yeah, one of the big things for any startup, obviously, is keeping your costs down. The last thing you want is, having some sort of lawsuit filed against you at the beginning stages of your operation. I know commonly you're drinking from a fire hose anyway when you're starting up a new operation. So that's the last headache that you need. These are matters which you can easily take care of through a process that we're going to be talking about today, a checklist for you. Make sure you go through that checklist, make sure you think about these issues because it can save you a tremendous amount of headaches down the line. And again, we're going to dive into these in more detail. The first one being the written offer letter or the contract, quote contract, with certain key employees. Now, certain employees, so-called blue collar folks, you probably don't need an offer letter, but you're going to have other people, more white collar in nature, where you'll want to submit some sort of understanding. And that's really fundamental here, an understanding to that employee. So they understand such things as their compensation. So there's simply no confusion about that. Same thing regarding bonus eligibility, if that happens to be something you want to talk about. And these days, obviously, working from home, what are the arrangements for that? How are you going to deal with those issues? So those sorts of key factors you want to lay out in your offer letter. Including at times what's referenced here in the slide, what's referred to as an at-will disclaimer. Unless an employee is subject to a true written contract, they are considered under the law to be at-will employees. They can leave anytime they want, and the company can discharge them anytime they want. So it's a two-way street for both sides. The exception is when you have an employment agreement, which basically lays out all the key details of their employment, but also specifies a term of their employment, 1 year, 2 year, 3 year, 4 year, whatever it is. But absent that, they're considered at will. And you want to, in most situations, make clear in your offer letter that these employees will be at will employees. You want to use that language. And you also want to refer to that in that offer letter, any other key documents that you think are necessary for the employment of this person. You know, maybe you've got certain matters, which IP matters in particular, you want to make sure remain confidential. You want an agreement covering those issues. You may want to ensure the individual isn't going to run off after 6 months of all the information he's gained from your startup and go start his own company. You know, then therefore you want a non-compete provision as part of the offer letter. So those are some of the considerations you really need to think about when you start employing people. Initially, it's the offer letter, and then it's also the additional matters, the other key documents that may be necessary to be included as part of that process.
Yeah, and as Terry mentioned, this is not an employment contract. This is an offer letter. It's to avoid confusion and ambiguities down the line. You would like the employee to acknowledge it when they sign it, you know, whether that's the compensation, their willingness to work on site for 3 days, 5 days, whatever it might be. But again, it's not necessarily an employment contract. You want to make sure that you're maintaining that at-will employment.
The other issue I see a lot when I sit down with somebody who's just starting up a company and they're trying to figure out, you know, everything under the sun, how they're going to operate things. You know, they always, a lot of them tell me, oh, I don't want any employees. All my people are going to be independent contractors. Well, you know, it doesn't work that way. You can't just designate somebody an independent contractor. You can call them whatever you want. It won't make a difference. It really is a function of, okay, what are their job functions? Are they reporting to you directly? Do they have any other outside employment? Do you control when they show up for work? Or do you control what they work on? They may be an employee. And you're going to be stuck with all sorts of issues down the line, including, you know, back taxes, unemployment appeals, you know, all sorts of issues. If you don't figure out this on the front end, you've got to have a really good understanding on who's an employee and who's a contractor. Chances are, 9 times out of 10, they're going to be considered an employee. Having a contractor status, independent contractor status, is very difficult these days to establish. So keep that in mind. I'm not going to bore you with all the legal mumbo jumbo, but I will tell you that you need to sit down with somebody, either an accountant or an attorney, and go through some of these issues. Because if you don't, it's going to come back to haunt you. And again, if there is a independent contractor relationship, the best way to truly firm up and establish that is to have a written agreement covering that arrangement. But I will tell you, the written agreement does not control. It's how they actually function in the workplace. You know, so that's going to be critical. So don't think just you call somebody an independent contractor and wave a magic wand, and that's all it takes. It doesn't work that way. More? There's more. Another issue you run into all the time is this whole concept of who's exempt from overtime in particular. And this is kind of goes hand in hand with the independent contractor situation. You know, people come in and say, well, I'm not going to have to worry about overtime because all my people are going to be quote salary. I'm just going to pay them the salary. Or all my people are independent contractors. But we've already talked about the independent contractor issues. Now let's talk about this exempt, non-exempt classification. You know, business of law has been around forever. And the Department of Labor, the federal agency which polices this environment, has got these concepts nailed down to a T. And they will come after you big time if there's a complaint by an employee about not receiving overtime. And that's how you normally get drug into this, is that some employee starts to work for you. And again, maybe you didn't set out an offer letter where they understood what their status was going to be and how they were going to get paid. And then a month later, they're finding out, well, wait a minute here, I'm not getting paid overtime. Why is that? And you come back and say, well, you're a salaried employee, therefore I don't have to pay you overtime. Well, again, it's not that simple. What you call an employee doesn't control. It's, again, their actual duties and functions in the workplace that do control. It's a so-called duties test that the federal statute provides. And therefore, if unless an employee comes under certain exceptions noted in the slide, they're classified as an executive, an administrative employee, a professional, a computer, or outside sales employee, then you got to pay them overtime, folks. And believe me, these exemptions are narrowly interpreted by the Department of Labor. For example, don't think someone works on their laptop in the office, if they get covered by the computer exemption, you don't have to worry about paying them overtime. That's a very limited and specific exception under the statute. The regulation is quite clear that they have to have some enhanced status in terms of their computer skills, and they're adding a great deal of expertise in their status as a computer employee, as it's referred to. That really does the name an injustice in terms of their duties and functions. But again, there are these various exemptions that you need to go through if you want to try to accept somebody from paying overtime. And you've got to go through that with, again, either an accountant or an attorney, or it's going to come back to haunt you because an employee is going to complain. They're going to run down to DOL. Believe me, they will find them, the Department of Labor, and you're going to have DOL come in, want to do a full-blown audit, all your payroll, and then not only is that employee going to be implicated with back pay, all your other employees will be subject to the audit too. So it just blows up on you. So this, again, fair warning, be aware of this problem area.
So the next two slides are going to be about restrictive covenants, and on two different ends. As we discussed at in the introduction slide, one of them is when you're onboarding new employees to consider the restrictive covenants they have with a prior employer. So as you can see here, we want to avoid breaching their obligations and their duty of loyalty during the recruiting process. When you are bringing on new employees, again, you need to have them let you know of any restrictive covenants they might have. Do they have duties of loyalty to a prior employer? What is the extent of the duty of loyalty, their obligation there, and make sure you're not enticing or encouraging or participating in any breach in that regard. The next would be the kind of probably more common and one that you might be more familiar with, and that's a non-compete or a non-solicitation covenant in the written agreement. Again, if you are hiring an employee and onboarding them and they worked with a prior employer, and as part of that employment they had a non-compete, and potentially you are one of the entities that would be considered competition by their prior employer. Well, again, as we talked about at the start, we want to avoid unnecessary and costly litigation. And this would be a situation where the prior employer might feel scorned and sue not only the former, now your current employee or potential current employee, but you as well as the onboarding company. So we want to make sure that as you're onboarding employees, you're aware of what restrictive covenants they might be subject to, and make sure you avoid breaching them. That doesn't necessarily mean not hiring them, but it's making sure they're working in a department or working in a manner that would not be in competition with the way that the restrictive covenant was drafted with their prior employer. So again, another provision that might be included in a written agreement with a former employer would be one not to disclose confidential or trade secret information. If that is in there, you want to make sure that you are affirmatively telling the employee as they're being onboarded not to disclose that to you, to operate and conform to the written agreement and the duty not to disclose confidential or trade secret information to you as the new employer, any of that information from their prior employer. And so when you're onboarding them, you want to consider having them sign an onboarding agreement. That would be like the offer sheet, an acknowledgement that they are not subject to a written agreement that has any of the above, as we just discussed, non-compete, non-solicitation, et cetera. Or if they are subject to any of these restrictive covenants, an acknowledgement that they affirmatively will not be violating them, whether that's it's stating that they will not be disclosing confidential or trade secret information. Again, that's just a process that's important to go through as you on.
And it's really important, and it's such an easy and cheap way of having some insurance here, folks, because under the law, the only way that you can be responsible as this new employer hiring this new employee in breach of the non-compete is if you knew they were subject to the non-compete. So if the employee signs an agreement telling you, no, I'm not part to any sort of agreement of that nature, that's a total defense. And you can weigh that paper in front of the judge and say, look, we asked this employee and he told us, no, he was not subject to a non-compete. We had no knowledge, and that therefore bars any claim against us. So that's why that's so important. And it's so easy to do.
So as I mentioned, the next part we're going to talk about is the covenant agreements for new hires to protect yourself moving forward. And this is going to come up in the inevitable, as I'm sure everybody's followed, there's a great deal of employee departure, a great deal of turnover right now, the great resignation, as they've called it. So inevitably, as you grow, as you continue to develop, you will inevitably lose employees. So we want to make sure that you're protected when that happens. So we're going to talk about some of the different restrictive covenants that you could include in an employment agreement for a new hire. We're going to talk to this in the third bullet point, but I do want to make you aware that you cannot have a blanket non-compete for all employees, no matter their role with the company. Non-competes are getting more and more limited by the courts and by the jurisdiction. Missouri is not California, and it is not Colorado, where they're completely barred, but still it is important to be truly reasonable to protect your interests. And there's a difference between a vice president and whether that be a blue collar worker or somebody a little bit lower down the line in terms of the employee hierarchy. So again, I wanted to make that clear at the start. So up at the top, we're going to talk about confidentiality and IP assignment agreements for all or almost all new employees. This is something you can do with most of your employees. Again, maybe outside of certain blue collar employees, but most you can. It's important for the obvious reasons. Protecting confidential information is something that does not need to be as restrictive as a non-compete would in terms of who can and cannot have it. The IP assignment is, again, often very important for startups that do have valuable intellectual property. The next we'll talk about is customer and employee non-solicitation agreements. Again, this would be slightly higher up, the sales and higher level employees. You want to make sure that as people are leaving, they're not taking your customers or other employees, soliciting them on the way out the door. I'm going to work for competitor X. Why don't you come with me to a coworker, or a month earlier to a customer? Hey, I'm going to be leaving in a month. Maybe hold off here, and we'll talk in a month at new business X. This is the protection there. And then a true non-compete, which would bar an employee from working for one of your competitors, should be reserved for key employees. Courts don't want to stay. It's not something we don't want to bar employees from moving around with new jobs. That's not something that is looked fondly upon. But when it is a high value employee with high value information and a important role for the company, non-competes are valid and considered valid if they are reasonable in terms of the temporal scope and the geographic scope and what you're barring the employee from competing. And then again, any type of restrictive covenant, any of these agreements must be supported by sufficient consideration. And they must be narrowly tailored, as we just talked about, with geographic and temporal scope. So as you're thinking about it, just make sure that it's not having somebody sign it and you're giving them not, you need to give them something as they're signing on. It doesn't need to be a massive dollar amount, but it's something to consider.
Yeah, the key thing here for non-competes is when you're drafting up this document, it's limited to protecting legitimate interests of the company. And those interests are usually customer information, especially somebody who's in sales and they have all the customer information for the entire company or for the region that they work in. And if that gets disclosed to your competitors, that could seriously undermine your operations. That's a protectable interest. The other thing is something that may be of a confidential nature, like intellectual property. Someone may be an engineer and they've helped design a major component of your operation. And if they leave, the disclosure of that information would also seriously harm your business. Those are the types of protectable interests that we're talking about that result in a need to have an employee sign off on a non-compete. If it's information that's commonly known in the industry, it's not a protectable interest. There's no reason to go through the process of having them sign a non-compete. It's only when they truly have what the law refers to as a protectable interest that you're allowed to have these sorts of agreements. So again, you may very well have that sort of interest come into play, but make sure you talk to an attorney before you go through this process.
And the last thing we're going to talk about in terms of employee departures is high-risk terminations. Again, the vast majority of your employees will be at-will employees, which does mean that you're able to terminate their employment for any legitimate non-discriminatory reason. But you do need a legitimate non-discriminatory reason. You're going to see the common discrimination claims by employees or ex-employees would be retaliation, but that's followed by disability, then age, race, gender. So that is known as the protected classes. If you have an employee that falls into one, two, or even more of the protected classes, or if there's some underlying issues that make you aware that this might be a high risk termination. And when we say high risk, that means a employee, soon to be former employee, that you think might file a charge of discrimination or a lawsuit against you based on the termination. That's something where, quite frankly, it's very helpful to bring an attorney in and have a conversation based on what type of risk is coming. A lot of this is risk tolerance when figuring out if you want to offer severance and get a release agreement and how much severance to offer. Potentially having an attorney negotiate that is helpful. Again, these are the high risk terminations. When you have them, you do want to consider the protected classes and making sure you're going about this in a way to limit liability and exposure to the extent possible.
And a lot of this is a function of, frankly, where you operate your business. City of St. Louis, you've got a higher risk of being hit with some sort of claim in this situation. St. Louis County, maybe not so much. So you really have to take into consideration where you're operating out of in terms of what sort of lawsuits pop up in those areas and what sort of damages result from claims of this nature regarding employment discrimination claims in particular, because the risk factor varies considerably between jurisdictions. All right, employee handbooks, near and dear to my heart here. For a long time, I'll be honest with you, I wasn't a real fan of employee handbooks. I thought they were probably overkill. You could probably just post your work rules in the lunchroom and that would probably take care of it. Of course, that was, 35 years ago. Things have changed. And now there are all good reasons to have an employee handbook. One, I think the atmosphere in any employment situation has changed in the last 30 or 40 years, so that employees expect to know what I refer to as the rules of the game. What are your expectations of me as an employee? Be it something as simple as attendance, leave policies, what do I get in the way of benefits? Where can I go to get more information? Which these days it's easy. You can just have a hyperlink or have the whole handbook online, and it makes life so much easier. There are good reasons to have an employee handbook. Unless it's
And again, some of the things you can include in here is something as simple as a dress code. And if you want to lay out what is appropriate to wear to work, if it's a dress for your day policy, if certain job functions require different, if it's client facing versus non, this is all the type of thing that can be included in an employee handbook. And as Terry said, gives onboarding or current employees an understanding of what's expected of them moving forward. And it's something that the employer can point to throughout the years as things pop up of, if it's something like a dress code issue, it's, well, here you acknowledge the employee handbook. And, we do require client facing individuals to wear, not many do, but a sports coat and a button down on certain days. So that's the type of thing that can be included there.
Believe me, he never wears a sports coat. So, yeah. So anyway, yeah, again, there are good reasons, but probably more important reasons these days are this slide, because the case law has developed over time a number of situations where handbooks can be a really good defense when employees bring up claims. So, for example, certain policies we consider required in any handbook. One is an EEO policy, where you specify that, hey, we treat everybody equally, no matter what their status is. And there's all sorts of good examples of that policy out there that you can utilize in the workplace. But you want that to be known. You want that to be part of your identity as a company, that we treat everybody fairly. We're telling you right up front. So, and it's important that be in your handbook. Also, reasonable accommodation policies. This reflects upon employees who may have a disability. Under the Americans with Disabilities Act, if someone is considered disabled, the employer is required to reasonably accommodate that employee so they can perform the essential functions of their job. But what's a reasonable accommodation? Well, that depends upon all the facts and circumstances. But the courts have made it very clear that you're better off as an employer that you specify that you will reasonably accommodate your employees. You look like the good guy. It's just that easy. That's just one of those things you want to put in your handbook. The same thing regarding harassment. Let's face it, we see every day another lawsuit being filed by employees for all sorts of harassment, race, sex, age, whatever. And the courts have made it very clear that employers must, I emphasize this, must have a harassment policy to really get by this sort of litigation. So you need to have a policy regarding, okay, if somebody thinks they're being harassed, how do they report that? How do they resolve that situation in a workplace? Who do they contact? What's the process? You really need to have those sorts of issues outlined in your handbook, because if you don't, frankly, the first thing that a plaintiff's attorney is going to point to is, look, these people don't care about harassment. They don't even have a policy in their handbook, So you don't want to be that person, trust me. You want that to be in your handbook. And again, the last two items, you want something in your handbook commonly referred to as a disclaimer indicating that employees, unless they're subject to a written contract for a set term, are at will, and so you want that specified in your handbook in black and white. And then finally, you have an acknowledgement form. You want to make sure that every employee signs off and indicates that they've read and reviewed the handbook, so they can't come back later and say, I never saw the handbook. I never got one. No one gave that to me. You just, have them sign it, have them date it. Then there's no dispute when you come back and say, wait a minute, here's our policy on attendance. We gave this handbook to you or gave you access to it online. Here's the acknowledgement form. You indicated you received it on X date. And now you say you never received it, So, you can just impeach them regarding their credibility. And believe me, almost every plaintiff says, oh, no, I never saw that rule. I don't know what you're talking about. Nobody told me about that. But if you've got this acknowledgement form, you can just throw it back in their face. There's nothing better than having that. Believe me, nothing better than having that in your back pocket.
So Terry covered most of these, but these are just some things that a harassment policy should include. And I'll briefly go over some of the ones in addition to what was covered. And that's the assurance of a prompt investigation, assurance of confidentiality to the extent practicable. Sorry, I'm struggling to speak that word. So that's important to realize that it's not 100% guarantee of confidentiality. If an investigation needs to happen, sometimes you will have to speak to witnesses to find out what's going on. So again, it's confidentiality to the extent practical, and then we'll moving from there. The next would be the assurance of appropriate remedial action. Again, making sure that the employees know that they will be protected and that harassment is not permitted. And lastly is the prohibition of retaliation. That's very important to include as well, because as we've discussed, retaliation is the number one claim that a employee might bring. Again, briefly, just a few more considerations. Employee handbooks can be quite dense in terms of what's in them. So I want to make sure that we go over some of the things to consider: the at-will employment, making sure that you're aware of state laws. We want to acknowledge in the handbook that the handbook is not an exhaustive list of policies. Oftentimes you will have standalone policies for certain employees, whether that be a dress code for your blue collar assembly line employees or maybe a client facing salesperson. You would have separate dress codes that are outside of the handbook. For the behavior and conduct, again, you want to be very clear that any list of prohibited conduct should be explicitly non-exhaustive. You don't want somebody coming back and waving the handbook at you and saying, well, here you said these 7 things, but you never listed theft as something that was prohibited. Well, you want to make sure that that's non-exhaustive. You could have computer technology and communication policies within it, something that states that there's no expectation of privacy. That's something that is often included with, company emails, firm monitors, etc. Depending on the type of workplace, the type of workforce, you might want to have a violence in the workplace provision. And then lastly, some employers want to include alternative dispute resolutions. That might be an arbitration agreement, stating that if there is a dispute, this will go to arbitration and not to litigation. Again, the employee handbook, for the most part, outside of the harassment policy and some other things, is up to your determination, your discretion of what to include, what not to include. So we are briefly going to discuss a couple of leave considerations, and very briefly and actually, we're just going to discuss the ADA because I don't think we have enough time to go through both. And quite frankly, most startups and entrepreneurs will not have the employee reach the employee threshold for the FMLA to kick in. So we can avoid that for today. I'm going to give a brief overview on the ADA. This implies regardless of the employee threshold, the employee number. The ADA is the ADA prohibits discrimination based on the actual or perceived disabilities of an employee. And the two bolded phrases here on the second bullet point, if you're going to take anything out of this section, it's that if somebody has an actual perceived disability, it requires the ADA requires the interactive process between the employer and the employee and reasonable accommodations for employees with actual disabilities. A reasonable accommodation, as we will discuss here, is you can require your employees to perform the essential functions of the job and maintain performance standards. Accommodation is a change in the work environment that enables an employee with a disability to enjoy equal employment opportunities. Again, I think the key here is that last line. It's an accommodation is not reasonable if it causes an undue hardship upon the employer. That is deciding upon a reasonable accommodation is at the discretion of the employer. The employee cannot pick and choose which reasonable accommodation he wants his employer to provide.
Yeah, I mean, and that's really where the conflict often comes up in reasonable accommodation is what's reasonable. And oftentimes reasonable, frankly, is defined by economics. Does it make sense that the employer has to buy some elaborate piece of machinery that's going to cost, several $1,000s for the employee to be able to perform their job functions? Is it reasonable, given the size of the employer and their operations, to put that burden on the employer? So, again, that's usually a big part of this. But there are other accommodations that aren't so costly. And here we're outlining some of those. Maybe it's a situation where the employee needs ongoing medical treatment, and therefore needs an additional leave. And one of the factors the court has defined as being a possible accommodation is providing them additional leave. Yes, they're treated better. They're treated special, but it's because of their disability. And you may have other employees who complain about it, but the law specifies that you may have to accommodate people in that situation. Again, workplace accommodations, more or less those situations in which there's some sort of mechanical process that needs to be modified. And again, that usually is a function of cost. And frankly, if you're a fairly sizable organization, that defense isn't going to go very far. But if you're a startup, yeah, it can have a big impact in terms of your ability to accommodate an employee. If you've only got, 5 employees, and this employee is going to have a substantial impact on your bottom line due to this accommodation, whatever it may be. Yeah, that's something that's legitimate. So keep that in mind. And again, also there's an ability for you to reassign the employee to a different position within the workplace. Now, again, if you're a startup, you may not have a lot of flexibility here. You may not have 94 different classifications of employees, and therefore you can just relocate this employee to pushing a broom back in the warehouse. And that's not feasible. But reassignment in the broad sense is something you probably need to have on your checklist if you're dealing with this sort of issue.
And so just to make sure we have enough room for questions at the end, I'm going to very briefly discuss the interactive process. It is still very important, so make sure you're engaging in it. This is the process where the employer management will gather information from the employee. This could be a doctor's note, anything along those lines, hearing the employee's concerns, what they might need. This is where the employer will consider the feasibility of the request, the likelihood of the success, any outside assistance that's necessary to accommodate. And the employer, again, has the ultimate discretion to choose between effective accommodations. If the employer decides there's 2 or 3 possible reasonable accommodations, or the employee suggests one and the employer comes up with another, the employer has the discretion. At this point, the employer will decide whether or not to grant a reasonable accommodation request to propose an alternative accommodation, or to deny the requested accommodation altogether. One of the most important things I would recommend for any startup or entrepreneur that is dealing with an ADA request is to document each step. That's having a witness in the room for some of these conversations to take notes on what is said, what is requested, to take notes on the consideration, and to have the employee sign off on any document that would state what the reasonable accommodation is, and if they're willing to accept it.
And this is important because oftentimes employees can be very unreasonable. I know it's shocking to many of you, but yes, that can happen. So your best just to document that unreasonable behavior in writing, and having a witness there too is also good, because again, time and time again, these cases go away because frankly, the employer engages in this interactive process and is trying to be reasonable, and the employee is saying, no, you got to do this, and this for me. Nothing else will work. Sorry, but that's just not the way the interactive process works. So better to document that quite well.
And the last thing we haven't covered from the summary slide here is just to avoid blanket policies. We've discussed the rest, but the ADA accommodation process is case by case, and it's very fact specific and fact intensive. So again, it's important not to have a one size fits all policy for all of your employees. And I'm going to skip through the FMLA and leave room for questions. So if anybody has any questions, now is the time. And thank you for taking the time to listen to us here. Hopefully this was helpful for all of you in terms of these considerations.
Thanks, Terry and Blake. Yeah, so if anybody does have any questions, please feel free to chime in.
Yes, this is John LaRose with AgWiki. I have a question. Is there a such thing as a boilerplate employee handbook?
Well, yes and no. I mean, there are certain key terms that can be, set out in a handbook that normally we sit down with the client and enhance those terms to fit their specific situation. If you just try to pull something off the internet, you're probably going to get yourself in trouble.
I would agree.
Right now, because
Yes.
there are just different laws that come into play. And maybe that handbook was applicable in Wisconsin or Florida or California, but in Missouri or Illinois, it's got some illegal terms and some things that just won't fly in Missouri. So, it's best to spend a little money up front on some of those issues to get those resolved, and you don't have the headaches down the line. Again, I don't know, the Missouri Chamber of Commerce might be able to help you out in that area. Sometimes your local Chamber of Commerce can assist you. In the old days, they would. I really haven't checked into that recently, but just a thought.
Yeah, it's something that, all the things you spoke about with the contracts, we've really found ourselves in a really good place with those, but we've never ever implemented an employee handbook per se.
Yeah. I mean, how many employees do you have now?
Well, contractors, we only have really technically one employee, but the rest of them are contractors.
Oh,
And
yeah, I've heard that before.
yeah, I know. And, our legal team is the one that designed it for us. Now, that doesn't mean that it's right, wrong, or indifference. They all of our team, except for a couple of us, have dedicated other careers. So
Yeah.
I'm not sure if that plays into it. And
well, but, just be careful with that contractor status. I mean, the Department of Labor in particular is, with this current administration is very, very aggressive on those issues. So,
and in terms of the employee handbook, I mean, we internally, we have templates we use with different types of clients, but again, it's something that if it's going to be rather simple, we're able to keep it very basic in terms of what is required and not adding a whole lot of additional things to it. But again, it's something that the employer should consider based on their jurisdiction and make sure everything is up to date on the changing laws that apply to them.
Very good. Thank you for that great information.
Thanks,
Sure.
John.
Sorry, I do have a question. I came in rather late in this conversation, and I assume you guys did talk, the gentleman was just talking about contractors, and we are trying to run very lean, and so we would be interested in hiring a 1099 contractor. I assume that conversation was had earlier on, and since this is being recorded, I could probably look at that off a link on a website versus, having the discussion again, or if you guys didn't really cover that, I'd be really interested to know sort of what the 2 cents is on bringing someone in as a 1099 as your, first quote unquote employee.
We did cover, but let me give you, the 2-cent tour once again, real quick. Be careful. Chances are, you may identify that person as a contractor, but in all likelihood, if you're controlling his workplace duties, when he comes in, when he leaves, his job functions, what he's working on, and that person is working exclusively for you, hey, it's probably going to be somebody who's considered an employee. And so, if you get audited, down the line, you can be liable for all sorts of back pay and benefits for that employee. So, it just raises a lot of issues.
Can you avoid some of those by saying, look, you don't regulate their hours? You may say, look, you can work 20 hours a week, whatever hours you want. We're not going to dictate that sort of thing to you. And then obviously, if someone's working for you, they have to, do the job you want them to do, but you may be more flexible, like, oh, there's no office. You don't have to go to an office. You can, put in 40 hours a week, but you can decide if you want to work Saturday or you want to work Sunday and you want to take Monday and Tuesday off. That's absolutely fine.
But he's going to, and that person's going to work there for what, the next 5 years?
Well, no, and that would be one of those things where this would be, the idea would be to take this person on, knock on wood, if it's the right person, as a full-time paid employee with health benefits. But at this juncture, that's not feasible for us.
I know. And all I'm saying is, look, think about independent contractors in terms of the construction world. You got a plumber coming over to fix your sink. That guy's an independent contractor.
Right.
He's not your employee. He works for 1 million different people in the course of the day doing various jobs. He may work for a plumbing contractor. He's probably an employee for them, but he's definitely not your employee. You don't have any control over, how he's going to do his job. Definitely these days when he's going to show up and fix your sink. So I just think you need to be very careful regarding this contractor. I mean, it's a function of how risk adverse you are in this situation. But I can just tell you, there's a lot of stories of clients coming in to see us because, they just got a letter from DOL or from the unemployment office in the state of Missouri because this person was let go by you. And so they go and file for unemployment and then you come back and say, well, he was a contractor. The employee says, well, wait a minute, I'm going to dispute that. So now you get a full-blown audit, and this may be, another year down the line where you've got maybe 2 individuals under contractor status. It's a huge can of worms.
Does it help if that contractor has set themselves up as an independent individual with their own LLC, and you say, look, I'm just hiring this LLC to do a particular job. They're an instructional designer for hire. They're a hired gun, and I'm saying, I'm hiring this person who has their own organization, that they've set up through the state of Missouri versus, I'm just hiring some individual and calling them a contractor.
Yeah, I mean, no question that helps. If in fact they are really acting in that fashion and they work for other individuals.
Gotcha. Okay.
We have another question in the chat, guys. It's from Evelyn. She's asking, is it important to have a current, thorough, accurate job description that justifies exempt or non-exempt status?
Yeah, if if you are trying to make the employee, and I can go back towards that slide as well. If you're trying to have the employee fall into one of the exemptions, one of the primary things you'll look at is the job description, the job duties of the employee. I think as Terry mentioned when we we're on the slide, what is drafted is not necessarily controlling. What is controlling is what the employee is actually doing. But you know, where would we start if we were auditing an employee or for an employer, if we were auditing their employee or a job title, we would start with the job duties to see what they're doing on a daily basis, what their primary duty, I believe, is the key term when determining if somebody falls into one of these exemptions is the primary duty, and often you will find that in the job description. So if your goal is to have an employee fall into one of these exemptions, I do think it would be important to have those job duties drafted.
And job descriptions are also important when it comes to the disability statute too, because you get into the so-called essential functions of an employee in the workplace and whether or not they can perform those essential functions with an accommodation. So the first place you got to start in doing that analysis is, okay, what the heck does this employee do? And among those job functions, how many are really essential functions? The core section of their duties and functions that they really have to do day in and day out to perform that job. And so that kind of starts the process. So that's another reason to have really solid job descriptions.
Yeah, and it's helpful in a variety of aspects, this being one of them. It can start, you know, rather brief with a handful of bullet points laying out the primary duty and the job duties for the employee, and it can grow as, you know, you have a better understanding of your company and what this particular employee is doing or what you expect them to do on a daily basis. It can come in handy, as in the situation Terry just said, in future litigation, if there were to be in terms of, or in a performance review, if you need to be able to point out what an employee is not doing at that time, if you were to terminate or try to move towards termination.
Again, I refer you back to the Chamber of Commerce, maybe your local Chamber of Commerce in particular. They may have some resources for you on this.
Any other questions?
I have one if nobody's got one online. Curious if you wanted to let's call them a full-time employee. I don't know how you're going to answer this question, but you want to have a full-time employee that does not live in the United States. How would you address that?
Boy, that gets complicated.
Okay, that's all right.
Well, and let me say, you know, you're going to have to reach out to a law firm that has connections in that other country, because you're going to have to coordinate the requirements of the employment law in that other country with what exists in the US. And I mean, we have relationships with various law firms in different parts of the world because this issue comes up so often. There's so many multinational clients that we represent. So then it can get, you know, very, very complicated.
So there isn't a way to just, I guess, how do I want to ask this? If a corporation in the United States brings on what would be considered a 1099 employee, they're somewhat functioning like a subcontractor, or they're functioning like an employee, but is it still illegal for us to bring them on as a 1099, even if they're functioning in another country like an employee?
So they're still working outside the country, right?
Correct. They're in another country. They're effectively working just like an employee would. Is a United States corporation held to the same legal standards if they're outside of the country?
Well, again, they're going to apply the law of the country where the employee is sitting.
Gotcha. You might be a lot if their laws are a lot relaxed.
Yeah.
So, yeah, you may be lucky. It may be laws may be more beneficial to you in that country versus being in the US.
What risk does one run just signing a contract and saying you're gonna work 40 hours a week? I don't care when you work, but you're just gonna be a 1099. Will the DOL come back and have the same audit issue?
Again, they're not going to be controlled by DOL. They're going to be controlled by the laws of the country they're sitting in. And I don't know what country this person might be in, what be performing the work, and don't know their laws. So that's why it gets really complicated.
Okay, thanks.
We have one more question. I think time for one more. Ellen is asking, should founders be considered as employees? And if so, does the company need to add all the additional employment agreements in addition to the founder agreement?
Well, normally when you're forming a new operation, you have various corporate documents that are going to take care of those issues. So in the formation, but if you're an officer, quote, founder, whatever term you want to use, you're going to have documents that will control in that situation. And that should be part of the process when you talk to an attorney about formation of your company. You should also be talking about operating agreements, things of that nature, that specify the duties and functions of the various officers. So that should be part and parcel of that whole package when you initially incorporate.
Kind of like the key employees, you have something a little different for them? Is it what you're saying, similar, like, or?
Well, key employees are normally one step below the officers or the founders.
Right.
But yeah, I mean, you could, if they're a key employee, then they're an employee. They may be a high ranking employee, but they're still an employee. They may not be an owner of the company. It's probably the biggest distinction.
Well, we thank you again. And for those that are still online, we're going to be having another session with Hush Blackwell next month. I believe that's going to be over some real estate considerations for startups. So that's going to be coming on that next Innovation Matrix in July. So thanks again.
And just a reminder, folks, we have all sorts of information on our webpage. You can seek it out, obviously, for free, be it real estate, labor and employment, immigration, you name it, it's on our webpage. And in these days, we're giving away a lot of free information because our clients were more or less demanded. So take advantage. Come look at it and do a surfing of the website. You may find all sorts of goodies.
Yeah, specifically in L&E, we have a lot of blog posts and articles in the labor and employment part of our website. So hopefully that could help assist some of your questions as they come up. But if you have any further questions, please do not hesitate to reach out to Terry or I, and we would be happy to answer them. And I hope you all have a great rest of your day.
Thank
Thank you
you.
very much. Thank you.